Hello, my name is Dr. Mary Guy. I'm a lecturer at Lancaster Law School, and today I'm talking about what removing competition law from the English NHS means. So what I'm talking about is the development of competition, how it relates to the wider relationship between the NHS and private healthcare sector, the separation of purchasing and providing functions, which has characterised different phases of competition, focusing on the controversial Lansley reforms, the Health and Social Care Act 2012 and the 2013 regulations, and the current plans under the NHS long-term plan to remove competition law from the NHS, which came in last year. So these plans have been described as deregulation, not demarketisation, by Andrew Taylor, who was director of the Cooperation and Competition Panel, effectively a competition agency within the Department of Health under the last years of the new Labour government. So the NHS long-term plan relates to a characterisation of deregulation. It's concerned with removing CMA oversight, Competition and Markets Authority oversight. It's concerned with scaling back the competition powers of NHS improvement, but doesn't seek to address the underlying interactions between, for example, NHS and private providers. Demarketisation approach, on the other hand, would examine some of these underlying features in addition to questions of oversight. So I'm illustrating this by reference to two earlier legislative proposals. I'm going to conclude with some thoughts on where we are now. Some of this research draws on recent research of mine, a book which came out last year, Competition Policy in Healthcare, which looks at the Health and Social Care Act by reference to the experience in the Netherlands of introducing competition in connection with mandatory private health insurance, and an article examining the wider relationship between the NHS and private healthcare and how this underpins the competition reforms. I'm going to start. Competition in the NHS relies on two aspects: this wider relationship between the NHS and private healthcare, which has existed since the inception of the NHS, and the separation of purchasing and providing functions introduced in the NHS internal market, designed in part by Alan Enthoven, the US health economist, who also influenced the Dutch reforms. And these two aspects give rise to what I call four categories of English healthcare. Category 1 relates to NHS trusts and foundation trusts treating NHS patients. Category 2 relates to private providers treating NHS patients. Category 3 is a kind of mirror image of this, in that it's NHS providers treating private patients in private patient units. And category 4 would be private hospitals treating private patients. So the focus today is very much on categories 1 and 2. And in addition to this sort of separation of functions being enshrined by the Health and Social Care Act and the 2013 regulations, I'm going to mention briefly two new Labour policies which were similarly enshrined. So the expansion of private sector delivery of NHS services by reference to the purchaser-provider split, and also the upgrade of NHS trusts to achieve foundation trust status, policy in operation between approximately 2004 and 2014. And the fact these have been enshrined by the Health and Social Care Act and the 2013 regulations explains part of the problem. Enshrinement suggests a particular direction of travel. Of course, what's happened since then, the NHS 5-year forward view, and subsequently, has been a shift away from competition and in favour moving towards integrated care models. So reconfiguration, such as sustainability and transformation partnerships, reforming interactions between NHS and independent sector providers are taking place against a legal framework which is no longer fit for purpose, and it's this which the NHS long-term plan seeks to address. Thinking of these two policies and how they relate to competition law, or what competition law means in this regard. So expanding private sector delivery of NHS services, we could be looking at prohibitions on anti-competitive agreements where providers agree to treat certain groups of patients or focus on a certain geographic area. We're looking at the prohibition on abuse of dominance, where a large provider can operate independently of its competitors. We'll be looking at public procurement rules governing the award of contracts for NHS services. We'll be looking at patient choice policies enshrined by the 2013 regulations, where NHS patients have a choice of an NHS or private provider in respect of elective secondary care. The sort of upgrade policy gets enshrined by Section 79 of the Health and Social Care Act, with its explicit reference of mergers involving foundation trusts. So what you can see from this is that there's a general law aspect, there's NHS-specific provisions. Questions of oversight have also proved controversial. The Health and Social Care Act made explicit for the first time that the Competition and Markets Authority, the CMA, would have oversight of the NHS, not just in terms of competition law, but also a review function with regard to setting the national tariff. NHS Improvement was originally conceived of as an economic regulator like Ofgem or Ofwat. It's evolved since then, but that was the original intention in the early days of the Health and Social Care Act. And then thinking about removing competition law, having had this sense of what competition law means, with the deregulation lens, what we see is the NHS-specific provisions fall away, oversight landscape becomes reconfigured again. We see the continuation of how to manage the interaction of NHS and private providers, falling now within the general law framework, not the NHS-specific framework. And the upgrade policy has largely fallen away with the move towards sustainability and transformation partnerships, but it looks as though NHS Improvement will still have a role in considering mergers. So, as I mentioned before, this long-term plan sort of conception, like deregulation vision, is largely concerned with questions of oversight being reconfigured and removing NHS-specific provisions. Demarketisation, on the other hand, is involved with other aspects as well, although it is also concerned with questions of oversight, as you can see. Both bills wanted to revert to the situation which existed prior to the Health and Social Care Act, whereby the Secretary of State would have oversight of the NHS. We wouldn't be looking to bodies such as NHS England or NHS Improvement. But what both of these bills do is engage with the exceptions available in law to sort of set parameters of the market where competition law would be applicable and could be useful. So the Amended Duties and Powers Bill was introduced by the Labour MP Clive Efford, received significant support on the second reading, was discontinued by the calling of the 2015 general election. What this wanted to do was to classify the NHS as comprising services of general economic interest, which amount to a partial exception to EU and indeed UK competition law. So this would involve separating out some services which would fall outside the scope of competition rules and those which fall within the scope of competition rules. The National Health Service Bill was first introduced by the Green MP Caroline Lucas, subsequently picked up by Labour MPs, and went further in that it classified the NHS as in terms of a total exemption, a service of general interest from EU, by implication UK competition law. Also classified the NHS as a complete exception under World Trade Organization rules as well. And in the current Brexit environment, this may be something that gets revisited. But as you can see, quite a different approach, so there are clearly different meanings to what removing competition law from the NHS can actually mean. Where we are now is clearly in quite a different place to where we were at the back end of 2019. So following the Queen's speech in December, which was making reference to the long-term plan, we were awaiting legislative proposals to start to come through. This has clearly, obviously, been delayed. Still anticipated by NHS England, thought to be happening in the autumn. At the end of last month, at the end of April, the CMA restated its commitment to the long-term plan, indeed to removing its powers in connection with NHS Foundation Trust mergers. So this was in the second review of the Dorset Hospitals merger. This particular merger was the first to be examined under the Health and Social Care Act reforms, and now it's been re-examined where it was blocked before. It's now been approved, with the CMA suggesting this is the final merger it will examine in this framework. I'm going to conclude by saying that the Health and Social Care Act 2012 competition framework is problematic for many reasons, and it's uncontroversial to say this. What I think we should be doing now with this opportunity for new legislation, opportunity to reform this flawed framework, is explore the exceptions and, where possible, avoid unintended consequences. So, for example, in the context of merger control, explore the exception available for public interest categories to relate to mergers which have implications for NHS patients, whether it's a merger of two private providers or NHS providers as well. And I would argue against removing complete CMA and NHS improvement oversight from competition law, because it may pave the way for private enforcement for bodies to pursue claims via the courts.